let's talk about applying logic and reasoning to legal analysis. There is a good reason that logic is tested so heavily on the law school admissions exam. Logic forms the heart of virtually all legal argumentation. Pretty much every single legal argument a lawyer or judge makes can be broken down into simple logical components. By going through this process of breaking arguments into simple components, you can figure out who's making the right argument and what people are arguing in the first place. Generally, legal arguments can be broken down as follows. First, the major premise. This is generally some rule of law or legal standard the party's trying to meet. Second, the minor premise. This will be the facts that happened. And finally, the conclusion. This is the logical conclusion that follows from applying the law to the facts. So, for an example, a major premise could be to qualify as a citizen of a state, a person must reside in that state. A minor premise would be the plaintiff does not reside in Nevada. Conclusion could be the plaintiff is not a citizen of the state of Nevada. This simple framework can truly help you decipher arguments and their merits and put them together yourself. Simply by checking to see if the lawyer properly moves from step to step, correct law, correct facts, and importantly, the correct conclusion, you can always be on top of every legal argument. So, another example, if a party says major premise, driving on the wrong side of the road is often negligent. Minor premise, the defendant was driving on the wrong side of the road. And then conclusion, the defendant was negligent. We can easily see the problem here. The conclusion does not follow from the major and minor premise. The correct conclusion would be the defendant was likely negligent, not that he was negligent. So let's talk about some other ways to spot when a lawyer does not properly move through these logical steps and commits what's called a fallacy. One big fallacy is where the premises look good, but the lawyer has misrepresented one of them. For example, where a lawyer misrepresents the major premise, what the law says, or where a lawyer misrepresents the minor premise, what facts happened. Next, look out for an appeal to the wrong authority. This happens where a lawyer cites to authority that is not binding, such as a secondary source or a decision from a trial court in another state, but treats it as binding, probably because they couldn't find any good law in the right jurisdiction. Next, watch for a disconnect between the premises. This happens where the minor premise does not follow the major premise. For example, if a major premise is murder is a killing of a human with intent, and the minor premise is the defendant was found in the area of the murder and is a felon, and the conclusion is therefore the defendant is guilty of murder, you can see the problem here is that there's no attempt to make the minor premise connect to the major premise, which are the elements of the rule. Another important fallacy is false cause. And this is assuming that something caused a consequence just because it happened right afterwards. So, for example, arguing that nuclear tests caused climate change because underground nuclear tests in Nevada precipitated dramatic climate change in the area. Another important fallacy is an extreme application of a general principle. This happens where a lawyer stretches a general legal or factual principle much farther than it's meant to go. For example, my client's new rafts are made of state-of-the-art material, so there was no false advertisement saying they could go across the ocean. Something else to look out for are hasty generalizations. For example, plaintiffs say junk food is bad for you, but I've been eating corn dogs and french fries my whole life and I'm in perfect health. It's clear why this is a fallacy. The conclusion is based on woefully too few facts in the minor premise. Next, look out for circular arguments. This happens where the conclusion is proved by the major premise. For example, a man who has studied law to its highest degree is a brilliant lawyer because a brilliant lawyer has studied law to its highest degree. Next, look for complex questions, where a question subtly assumes some important conclusion. So for an example, isn't it true that your sales increased dramatically after these misleading advertisements were published? This question assumes that the advertisements in question are misleading without actually proving it. Next, look for composition. This is assuming an aspect of a part is attributable to the whole. So, for an example, the prosecution has offered nothing but circumstantial evidence. No single piece of evidence proved the defendant's guilt. Therefore, the prosecution has not proved the defendant's guilty. Also look out for division. This is the opposite of composition. It's arguing that aspects of the whole automatically apply to a part. For example, the defendant belongs to the Hells Angels. The Hells Angels are a violent gang. Therefore, the defendant is violent. Next, look out for arguments from ignorance. This is where someone argues that something is true because it has not been proven false. Now, sometimes in the context of a procedural standard or burden of proof, such as summary judgment, failure to disprove can matter. But often lawyers make this argument fallaciously by treating a fact as absolutely proven just because it hasn't been unproven. Next, look out for attempts to attack the person. Lawyers do a lot of this, bad-mouthing the other lawyer or the other party, even when it has nothing to do with any claims or defenses being raised. It can be hard to ignore these, especially when they are true. But unless the bad act has to do with a claim or defense, you must ignore it. Finally, appealing to emotion. This happens a lot by lawyers, especially in jury trials, reciting sad or angering facts in order to sway a decision maker. Ignore it. Hopefully, these examples of some common legal fallacies will help you apply principles of logic to legal analysis.